In a strongly worded open letter, former Delhi High Court judge and ex-Law Commission chairman Justice Ajit Prakash Shah has raised alarm over recent legislative changes to the Right to Information Act brought about through the Digital Personal Data Protection Act 2023, also known as DPDP Act. This act is India's first comprehensive data protection law aimed at regulating how personal data of individuals is collected, stored, and used by both government and private entities. It grants individuals rights over their personal data, such as the right to access, correct, or erase it, and requires organizations to process data lawfully with consent. However, it also gives the government powers to exempt its agencies from these provisions, raising concerns about surveillance and transparency. The law was enacted, but it has still not come into force. Now, the letter by Justice A.P. Shah addressed to the Attorney General R. Venkataramani cautions that the amendments to RTI Act through this Personal Data Protection Act seriously undermines the core purpose of RTI Act, that is, democratic accountability and citizen empowerment. Justice Shah's concerns stem from reports that the Ministry of Electronics and Information Technology has sought a legal opinion on whether the new act affects the RTI framework. In response, he has offered a detailed legal and constitutional critique. He mentions that Section 44, subsection 3 of the new Data Protection Act amends Section 81J of the RTI Act by simply protecting personal information from disclosure without considering its relevance to public activity or public interest. Previously, information could still be disclosed if it served the public interest. That override is now gone, meaning even information linked to public corruption or misconduct may be denied outright. The Act defines personal data broadly, essentially allowing public authorities to classify almost anything as personal and block its release. This could include public servants' salaries, property records, educational qualifications, and disciplinary histories. Further, Justice Shah warns the Act could criminalize routine reporting by journalists. Under the Act, publishing names or photographs may be deemed unauthorized data processing, potentially attracting penalties up to 250 to 500 crore. The letter highlights that social audits, crucial for checking fraud in welfare schemes, rely on personal data like beneficiary names and expenditures. Blocking such data could cripple transparency efforts. Justice Shah has argued that the blanket restriction on personal data fails the proportionality test laid out by the Supreme Court in Puttaswamy versus Union of India, as it sacrifices the right to information without justifiable cause. He also criticizes the removal of a key proviso in Section 8(1), which earlier said that information that cannot be denied to Parliament should not be denied to any citizen. Removing it, he says, weakens popular sovereignty and that the RTI Act requires proactive publication of certain information. But the new Act's strict consent requirements for publishing personal data directly clash with this duty. Justice Shah has called for immediate repeal of Section 44(3) of the new Act and has urged the government to clarify that RTI Act continues to apply fully and independently without being overridden by the new data protection law.